everyone for being here today. So Devin, Taylor, and I are going to be addressing some primarily trial skills. I'm going to be focusing mostly on amendments to proof, and then also touch on marijuana smoke versus smell and some general nexus issues. And then Devin will take over with getting our clients prepared for testimony. So I wanted to start using my case In Re Ginger Tea. The citation for that is on the amendment to proof sheet that I prepared. So it is sort of a lengthy case, and I didn't want to print it out if people weren't going to be reading all of it, but it is very easily identifiable. It was unpublished, so you cannot cite to Ginger Tea, but you can look it up on the Court of Appeal website under the 2nd District, and you can read it for the arguments. The reason why I really like Ginger Tea, I actually mentioned this case at my training last year. At that point it was a pending appeal, and I had talked about it because I got appointed at the JDX date for the mother. Tom Picata was appointed for the father, and as I was reading the petition and I was reading the jurisdiction disposition report, the only allegation was a failure to thrive count. They didn't have any doctor's records, they didn't have any medical professional at all stating this child had failure to thrive. What they had was one statement from someone at Union Rescue Mission that said the child looked like they had a small head. And I went to Tom and I said, Tom, we have to go forward today. Primarily and usually what we do is we ask for a continuance when we get appointed at the date of the adjudication, but I am going to say that I've had a few different occasions now where I've been appointed at the date of adjudication and I've gone forward, and it has pretty much always been successful. I either was able to get the petition dismissed on that day, or I was able to get the child home at the disposition, which is what happened in Ginger Tea. I also have another case that is currently up on appeal, and I have the appellate attorney telling me he thinks it's a really strong case, and he and I worked together on another case recently where we did get Soto reversed. So I have never had an occasion to regret going forward on the adjudication when I've been appointed, when I'm doing it for the right reasons, when we're saying, okay, there really are not enough facts here, and why are we going to give DCFS more time now to get the facts? We have to always remember they have the burden. And similarly, sometimes we think, well, we want to file 355s. I am always very hesitant to file 355s, and I'm always very, I think when I first started my practice, I was sort of always filing 355s. And what I realized after practicing longer is we need to be a little careful when we do that, because, for example, in Ginger Tea, had I filed a 355 on this woman from the Union Rescue Mission, she may have come in and said, well, yes, I'm a worker at Union Rescue Mission, but I had 6 years of experience in child development training and have all of these other degrees, which were not in evidence, so why do I need her to come in and sort of rehabilitate her statements? So we went forward. Soto at the time did sustain the petition, but he did send the child home that day. And that was an important situation in terms of getting this little baby out of foster care as soon as possible. So I was able to, so it was very successful, and now I can report that we have the opinion, which again is unpublished, but they did reverse, and they said there was not enough evidence. Like I said, the citation is on the sheet. And what I will note, the other reason I wanted to talk about Ginger Tea was because they talked a lot about amending to proof. What I think's happened also in Ginger Tea is when parents aren't there at the detention, they don't have assigned attorneys, I think county council is also not preparing as much as they may be prepared in other cases. And so that's another reason why we want to take advantage of that and go forward as quickly as possible if the facts allow. Obviously, I'm not talking about E's or F's or things that are more complicated. So in the middle of trial, the county council, I think, realized this was a very weak petition, weak evidence, and started talking about amending to proof. So Tom Picata and I both objected to amending to proof. We talked about due process. We talked about how parents need to be on notice of what exactly the allegations are. And what the Court of Appeals stated was that a juvenile court may amend a dependency petition to conform to the evidence received at the jurisdictional hearing to remedy immaterial variances between the petition and proof, and that's the Code of Civil Procedure. It's stated here that juvenile court did not amend the petition to proof, and moreover, even had it done so, we would be bound to reverse, because the basis on which the juvenile court sustained the petition, the positive drug tests and domestic violence between mother and father, was fundamentally different than the parental misconduct alleged. So that's what we really need to be focusing on when people are talking about amendments to proof. The allegation, like I said, had been failure to thrive. But there was all this other stuff around this family. They were homeless, and there were, some people were talking about domestic violence, and the mother had tested positive at birth, but it was a non-confirmed test, and there was someone from Pacific Toxicology stating, yes, NyQuil actually could have a false positive with these non-confirmed dipstick tests that the hospitals use. So the only allegation we're dealing with is failure to thrive. And so in that case, not enough to amend to proof, and we have made our arguments about that on the record. Additionally, what I thought was interesting was the Court of Appeal here noted my objections that I made on the record in a footnote. Sometimes I think we feel like if you have a bench officer who you know is going to overrule any objections, they want to let everything in, just remember you're also talking to the Court of Appeal. So you want to get those objections on the record so that the Court of Appeal is looking at that, and they, like I said, even made note of that in the decision. Now, recently, there has been a case in Re Marcus C, which I don't know, has anyone heard of Marcus C? Has anyone been talking about that in their courts? Okay, so that's a published case. And in that case, it was a little strange, but basically the Court of Appeal was stating that because the court did not amend to proof that was a big mistake. The court did dismiss the petition. County Council and Minors Council filed a writ, and the Court of Appeal said, absolutely, the petition should have been amended to proof. All of the evidence supported amending to proof. We need to protect this child. And they reversed and remanded and said we need to amend to proof. And now I've heard that some hearing officers are now saying, well, I have to amend to proof. Has anybody had that experience? Okay. So I read in Re Marcus C, and again, I didn't print out the entire opinion, but the citation is on the amending to proof memo. I personally was surprised that this was a published case, because in my mind, this does not change the law at all. What it says is what we have known, which is that child protection issues are taken very seriously. The goal of dependency is to protect children, and we need to make sure that petitions are being found true when necessary to protect kids. But it does not change the law. It doesn't say now all of a sudden you can sustain anything. What it means is that you need to look at the facts. Now within Re Marcus C, there were horrible facts. The bottom line was that a child fell out of a window. The father and the mother were smoking marijuana. The child was an unhealthy weight. In this case, the child was obese, behind on vaccinations, not going to the doctor regularly. The child also had a speech delay. So you're looking at this situation, and there were a lot of concerns, as opposed to the case I had in Re Ginger T, where we actually had a statement from a doctor stating that child was meeting her developmental milestones. Again, all we had was this random person saying that the child had a small head. So you have to really look at the child that's at the heart of this petition and say to yourself, is this a child that's well taken care of, or is this a child that's being neglected in some way? My case in Re Ginger T would have been very different if that child had fallen out of a window or was of such a dangerous weight the pediatrician was concerned. All of these things. So in Re Marcus C, there are a lot of concerns. Additionally, there were a lot of statements from collaterals talking about how at one point the father was smoking in a parking lot and the child was running in front of cars. Just a lot of concerns. And the hearing officer dismissed the petition because, among other things, the only allegations were the marijuana allegations, and the parents were testing negative at the time of the hearing. So of course that feels like that was obviously a huge win for Parents Council in that case, but the Court of Appeal is very concerned. And so what they're stating is that the court failed to acknowledge the record was replete with facts well known to the parents, and that recognizing this circumstance by granting leave to amend to conform to proof would not have misled the parents to their prejudice. Instead, granting the motion would have given proper weight in this case to the strong policy of favoring such amendments when the adverse party would not be prejudiced. Moreover, the record contained additional facts determined from other sources contained in the jurisdiction disposition report and disclosed to the parents prior to the hearing, which support our conclusion that leave to amend was required. And interestingly enough, they quote, they're citing In re Jessica C., which is the same case that the court cited in Ginger T. to say you couldn't conform to proof. So again, nothing is being changed here. So when you're looking at this sheet that I prepared, on the third paragraph down, it states the fundamental inquiry is whether the proposed amendment would mislead a party to his or her prejudice. So for example, if you have a case where the only allegation is failure to thrive, and then they start bringing in an allegation about mental health or other things, well, that's going to be a problem if we need to subpoena therapists or if we need to subpoena medical records. But in my case, and again, in Ginger T, something about, domestic violence, drugs, all of these things, they have nothing to do with the failure to thrive. But with In re Marcus C, to be honest, I think that the allegations could have been sustained as they had been pled, and that's my personal opinion, because what they were saying was that drug use in this case was leading to this child not being properly supervised. And I think the evidence supported that, so I'm just not really sure what was going on at the child level there, but certainly everyone was on notice. There were issues with supervision in this case. There were issues with drugs. There were issues with just the general idea that a parent needed to be giving this child more attention. So what I am keeping in mind, on the back of the amendment to proof sheet, I did double-sided to save paper, and of course what I state here is bad facts make bad law. You just need to really be able to, again, look at this child. Is this a well-cared-for child, or is this not a well-cared-for child? And to me, there are just a couple key words you want to think about. You want to make sure you put on the record due process. Were these parents misled by the petition? Have they been prejudiced? And the amendment is not immaterial. And I think sometimes it's going to be a close call, because, for example, I would not have been shocked if my judge had amended to proof in the Ginger T case, because there were all of these allegations in the petition regarding the drugs and domestic violence. There was not enough to sustain, and I made that argument. But I did reference those issues in my argument because I had been put on notice that these were part of the general concerns. So you just need to make sure in your arguments you're addressing these concerns, and if you think there's an issue with amending to proof, you put these keywords on the record. If you have this sheet, you can cite to the cases. Nothing has changed. Courts are not required to amend to proof. They're required to protect children. But here, Your Honor, this child requires no protection. And then you say why, right? So that is what I would keep in mind with regard to the amendments to proof. And then in the time I have left, I also wanted to talk a little bit about nexus and marijuana and other drugs. So we hit this very hard. Everyone's aware. The nexus issue, just because we have some positive tests, that's not enough to sustain. We need to see that connection. I do talk about this other unpublished case that I have, In re DS. I talked about it more extensively at last year's training, so I'm not going to talk about it too much here, although there are a lot of new faces. But again, it is unpublished, but you can look it up on the Court of Appeals website with the citation on the marijuana smoke sheet. So in that case, again, I was looking at this child. This child was a well-cared-for child. It was actually twins. They were very healthy weight. They were meeting their developmental milestones. The doctors had wonderful things to say about the parents, but the parents were marijuana users. And they were heavy marijuana users. And there was a lot of smoke, and there was, they had marijuana cards. They were very open and honest about this. But at the end of the day, my argument was based upon these children. Did these children need to be protected? And They were taking care of these kids. Now, there absolutely was smoke in that home, and it was a small home, as most of our clients don't live in mansions. But in that case, the court said that although exposure to secondhand marijuana smoke can be considered in conjunction with other risks, and then they cite In re Alexis E., it's not enough by itself, and that's citing Carolina's case, Destiny S., one of the best cases ever. Good job. And again, they stated so holding in part because the logical consequence of the department's argument would be to remove minor children from the house of all smokers in Los Angeles County regardless of what they smoke. And that's just not a situation that we're dealing with. So I was really surprised when it was Anukamka had a reversal, also unpublished, In re GJ, also with the site, and that was Division 8. They reversed and remanded with directions because of a house that smelled like marijuana. So to me, this is even a step removed from smoke around children. This is just about the marijuana smell. And they're stating that the marijuana smell supports dependency jurisdiction because it can reasonably be inferred mother was not protecting the children from exposure to secondhand marijuana smoke. And then it goes on to state, In re Alexis E., in that case, the court found dependency jurisdiction based on the risk of harm posed by father's failure to protect the child from secondhand marijuana smoke. So here it's 2 unpublished cases, which is a good thing, with regard to GJ, but reading this marijuana smell versus smoke in a very, very different way. So in my mind, you just need to make sure you're making your records, because if the case goes up on appeal, you don't know which division it's going to go to, and you don't want to roll over, because to me, this is an area that's still changing. We're the ones who are at the forefront here, leading the Court of Appeal. So we need to continue to take these cases when we have good facts and when we have children that are being well cared for. Again, if you have a case where the kids are not being well cared for, the parents want to go to trial, fine, make your arguments, but be careful about what you appeal. Sometimes our clients file appeals without us, and that's a situation we have to deal with, but we can always talk to our clients and explain why we don't necessarily think an appeal would be appropriate, because as we know, bad facts make bad law. So for my records, what I am being very clear about with the smoke versus smell, I am talking a lot about Destiny S. and distinguishing Alexis E. One of the things that went on in Alexis E. was that the father was becoming irritable when he smoked, and that was another kind of hook to say, look, the smoking of the marijuana is placing the children at risk. So if you have a situation where that's not the case, it's not affecting your client's behavior, make sure you distinguish In re Alexis E. And then, even though the Division 8 was finding that even the smell is an issue, I am continuing to differentiate smell versus smoke, because in my mind, you can have a marijuana smell. It could be a neighbor, as we know many of our clients live in close quarters. It could be a neighbor in the next door. It could even be a roommate who's smoking with the door closed. The child's not in that room. You could be, a parent could be smoking when the child's at school, is not exposing the child to smoke, and is not under the influence when the child comes home. So I just don't think we certainly cannot be rolling over on this issue as far as I'm concerned, and I think there's a lot of arguments to be made about why a marijuana smell is not the same as marijuana smoke. So that's all the things I'm placing on the record. You know, that it's speculative, it requires a leap. We still need the evidence, and as we know, a preponderance of evidence is still evidence. You can't just say, it can't just be anything. So that is also how, so that's just something to think about, again, for your records. I'm a person who's experienced losing at the trial level a lot, but you have to always think about that record. Don't get discouraged about what's happening in the trial court, because things can change at the Court of Appeal level. And then the last thing that I wanted to talk about, I think I'm good on time, is what happens when you have a client who won't stop using. So, you know, you're arguing nexus, we're at the arraignment detention, we're asking for, in this case, In re LS, which I'm pretty sure I provided, so everyone has that. It is unpublished again, so don't cite it, but I did print it out because it's a slim opinion, and on page 5, it talks about what to do when the person won't stop using. So it was a methamphetamine case. I saw it. This was a case, again, I was absolutely ready to go forward on trial on the date I got the petition. So I had originally set this for a no time waiver, and then Judge Soto created this whole situation. He actually returned the father to the home, which I was not expecting, and asked the department to assess a 301 and ordered the father to continue testing. So I agreed to waive the time for all of these things to be assessed, and the father wouldn't stop using. And we come back, and it's just test after test of positive methamphetamine tests. So of course the father he was sort of denying it, and I explained to him these specific toxicology tests were not going to be coming back positive if he wasn't using, but there was no nexus. He was not using in the home. There was no paraphernalia. There were no drugs around these kids. His wife was the full-time caregiver for this child, and she was 100% appropriate, 100% sober. There was just zero nexus here. He was a house painter. He would go out, use methamphetamine, and work, and then come home when he was no longer under the effects of meth. So we won that case on appeal. Again, it was unpublished, but it does talk about, again, it talks about In re Rebecca C., which was another case of mine, but it talks about the fact that, that there was the father was responsible. Respondent's argument that father used methamphetamine after being admonished by the juvenile court does not demonstrate substance abuse. To me, what it demonstrates is that he just wouldn't listen to his attorney, because obviously I was telling him to stop. But it doesn't suddenly prove the department's arguments. And I think what ended up happening was everyone thought I was crazy to go forward with this trial because we had all these positive tests. But I just continued to hit the nexus issue, and I wouldn't roll over on this client because to a certain extent, I felt like he had a right to use. If this was sort of part of his house painting thing, and he's supporting his family and he's not putting his kid at risk, why do we need DCFS involvement? And I ended up being validated, so it was a good day. So it says, taken to its logical conclusion, this contention would eviscerate the distinction between substance use and substance abuse, and anytime and then it goes on to talk about Rebecca C., anytime DCFS identified a parent as a user and warned the parent to stop using, the use would then automatically rise to the level of abuse, a conclusion at odds with current law. So the next piece then is getting your clients ready for trial and ready to testify when necessary, and I'm going to hand it over.
All right, everyone. It's me, Devin Taylor from the Firth Firm, and I'm going to talk to you a little bit about client testimony. When we have the opportunity, which is not always, it's really good to speak to your client and set the tone of your case that day. Normally, especially with our clients, we don't have the luxury to have a single count that is just marijuana or meth. We have a trifecta. We have domestic violence, physical abuse, and a little bit of meth thrown in there. So it's not always as easy as we would like it to be. I usually speak to my clients and ask them, what were your reasons for using? Why do we use? And they're not always honest. They're deep in their addiction sometimes, whether it be marijuana or their hard drugs. So they won't tell you, but there are some that are very open and honest. And is at that time in my activity sheet, I put mom will be a good W, like mom will be a good witness. So from that moment forward, I know that I have a good chance, whether it be at dispo, the 2-1-E, or going forward, about how well my client will do. Now, as Emily had talked about in many of the cases, the Court of Appeal lets you know also what's important in terms of what was missing from the department's case. That is the opportunity for you to build upon in questioning your client, because they'll make wide assumptions or conclusions that might not be supported. For example, I had a client who smoked marijuana, and they'll say, well, mom, she's taking the children to school, but you didn't ask my client if she owned a vehicle. She didn't have one. She was walking her kids around the corner, but not only that, she helped serve breakfast at the school for a period of time. So she was involved in the school. The department wanted to make the connection that she was under the influence, taking her children to school, and not really being there for them, which was the total opposite. So there is one case that although cases are unpublished, that doesn't mean that you shouldn't read them. You can get a wealth of information from them. Obviously, you can't cite to them, but it's helpful. So a case that I looked into was NRA-NK. It is on the Firth Drive. You can look it up as well. It is not published. It's out of a Zeidler's courtroom, and it is an appellate 2nd District and Division 1. What was interesting about this case is that oftentimes, I don't have it on the handout, so don't look, but you can find it. Google search will help you, but I can also send the information, and Daisy can circulate that through all the firms. What was helpful about this case is that we often have clients like this. This was a case where there was marijuana use and there was a domestic violence incident between mother and her male companion. And the department had initially made contact with her and said, look, you know, if you would just agree to this, have him move out of the home, we can help you. So she's like, okay. But as a true victim, she actually called the department and said, you know, I want my man back, and you guys can just open a case. So that is what she did. And she consented. The baby tested negative at birth, but mom tested positive for marijuana. And she had a valid prescription. And she also had she had a valid prescription, but the department pled that mother also possessed, used, and was under the influence of marijuana while caring for the child. So mom didn't stop using marijuana. After detention, she didn't. She also failed and did not want to test. She's like, I'm just not doing it, oftentimes, and even though she was advised by counsel to do so. But the appellate court did note that the department provided no material facts mother's drug use harmed or even impacted the child. DCFS made no allegations mother failed to provide for the child's need or protect him because she was high. No evidence mother was ever high while caring for the child. Even if mother was using her prescription marijuana for non-prescribed purposes, there is no evidence this use affected her parenting abilities. And I point that out because you can elicit testimony from your client about how much they use, how often. It's also important to find out if it's edible, because some of our clients don't smoke, they eat, and that might not be in the report for whatever reason. Maybe there was not a thorough investigation by the social worker. I do think it's important too to ask what their edible looks like, because I think a gummy bear, which could be susceptible for children picking up, is different from another type of edible like a small brownie or something like that. I had a client in particular whose daughter just had an aversion to broccoli, and her mom told her, my medicine is broccoli and it's in this box, so like don't go in there. And so she's like, no, that's broccoli, like she just didn't have any, she didn't know what it was, and she was like, that's just off limits for me. I just know my mommy goes in there and I want no parts of that. So that was helpful for us because she was like, what are you talking about? So they will point you to where the department is lacking, which you can build upon to help get what you want for your client, whether it be a dismissal or later an argument that there's no risk because mother is not under the influence while taking care of this child. She's ready and available. She attends every IEP meeting. This is also something that you have to read all those attachments. You find a wealth of information attached to those reports, whether it be in the mental health, the MAT assessment, or some attachment of the school records. I do think being persuasive with the court is something too that causes them to pause and consider your argument. I think it's one thing to say, Your Honor, every time the social worker came to mother's house, she never appeared under influence. I think it's different to say, Your Honor, on November 10th, on December 2nd, on January 5th. I think that's different. Or even if you say, out of the 20 times the social worker came to the mother's house, not one time did they observe she was under the influence. And that causes the court sometimes to look like, well, oh my gosh, what is she saying? Same thing about your exhibits. When you admit them, use them. Don't just say, oh, here's mom's sign-in sheet. Say, Your Honor, mom did 76 NA meetings within this span of time. So it's important to be persuasive with your arguments, because it also sometimes you might have minors counsels against you coming in, but now they're listening to you, they're like, oh snap, and they start looking and like, mom has really done a lot. So sometimes it's just your audience and how you present your case. And that's also important in terms of looking at the client's social history. Although we are lawyers, we are also counselors at some point. You have to see what it is that might have caused your client to be in the situation that they are. And if they're not open to tell you because they think you're a part of the problem, that social history might do so. It might tell you that, You know, they were a victim of sex abuse. You know, their whole family were addicts, whether it be alcoholism or something else. And you can use that to build rapport with your client and say, you know, I've heard or I've seen in the report that you have a difficult past. Do you think that might be your trigger? And then they might start addressing that with you, and that might help as you go forward in your case. So to bring it back to the unpublished case, I will state that the department oftentimes likes to make a connection between substance abuse and the domestic violence. And there are some cases where that is the case, where you'll see in a police report, you know, there was a domestic violence incident, dad appeared to be under the influence, eyes were red, etc. But that's not always the case, and they just like to lump that in to prove their nexus. And in this case, the appellate court said the department also provided no evidence her drug use incited, exasperated, or prolonged the domestic violence, but they did sustain on the domestic violence grounds because clearly mom had a problem. She was letting this man back in her life. She had been given the opportunity. So make those connections. They're trying to be persuasive to the court. You can too. Like, there's no evidence that mom was under the influence or was engaging in any type of substances when this domestic violence occurred. That is helpful as well. Now, let's see. So you asked them what to use, how often, when. Can you describe it? I really was my very first case here. Dennis was assisting me with the marijuana case, and he had prepped mom, but he didn't realize she was going to say, when he asked her, like, can you describe, you know, what you smoke? And she said, oh, a blunt. And not all of our judges are educated, so feel free to ask your clients, what exactly is a blunt? Can you describe it? But she said, like, this long. And I looked at Dennis, I was like, is she exaggerating? Because how do you, I don't know. So that didn't go well. He's like, okay, Devin, that wasn't a good example. And I was just like, she had to be kidding, right? So ask them about these things. There's different ways to use marijuana, edibles, bongs, bowls. So you have to ask them. The court might not be familiar. And even the amount. There are different amounts that you can have. And you can just make an analogy. Was that the size of a dime? You know, is it a quarter? Like, what may the case be? So that can be helpful. In addition, you were asked about primary caretaker responsibilities and things like that. Lastly, I think it's important for attorneys to be informed about how a program actually works and what our clients are trying to accomplish in those programs. Oftentimes we ask our clients, are you working the steps? So we ourselves don't know anything about the steps. I think it's important for you to at least Google them and know what they are, because it also signals to your client that you care and you're interested, and you're not going to you're not going to pull one over on me, because I know. So the most important steps, I believe, obviously your client should be able to admit they're an addict if there are, but it's 4 and 9. 4 is the moral inventory, a fearless and searching moral inventory. And most clients, I ask them, what step are you on? And I say, what is the hardest? And if they say 4, I say, well, how did you do it? And they're like, what? I'm like, did you do a notebook? Did you do letters? Did you set it on fire? And then it gets them to open up. And then they really understand that we are here to help and we care about their recovery. They're not just always a client. Like, we're going to work as hard as our clients do, but you have to show us that you're putting in the work for us to make a compelling argument to the court. Many clients will say 4, other clients will say 9, which is making amends. And that is, you have to make amends to every person that you've harmed while you were an addict. So that's difficult for many clients, but some of them is easy. Like, I knew I was in my addiction and they can tell them. But these are important to educate the court about when you're revealing how much compliance they have in their program. When you get to DISPO or 21E or even a 388. I also have realized for strategy purposes, you might have a case that is reactivated and it's coming back again on substance abuse type allegations. You have to make a decision as to what to advise your client of going forward. Hopefully it's not a case where your client got returned at 2-2, because now you're kind of like screwed. But I asked them, what program did you do before? And they'll say, oh, I did Clinical Romero. Okay, well, why didn't that program work? And I didn't work my program, or I went back to the place I used to live, or I didn't do my steps. So sometimes I've advised, you know, maybe you should do an inpatient versus the outpatient if it didn't work. Well, on one hand, my client was like, this was a good program. It was just me. I want to go back. But that helped me because mom ended up having the same counselor. who could tell the court how she changed from the past to her second entry in this program. So that was an additional witness that I had that supported our case. But oftentimes I tell my client, if you did outpatient, let's do inpatient this time. Not only that, if there's a bed available, hopefully we can get your child to you in your placement. But those are things that you have to discover. Like, utilize those counselors that come with the clients. Talk to them about, the program, how your client's doing. That's helpful to your case. So always do that. And it's important too to get relatives on board too if they've seen your clients in their addiction. I've called caretakers who have been placement as well, and they'll compare how mom was prior in her addiction, but how they see her growth now as she's visiting and the progress that she's made in terms of taking care of the children, just being a mom, although the children are suitably placed with the grandmother at that time. And obviously, we should push for placement in our programs. I believe the RFA is going to make it difficult for a lot of our clients' families to have their children in their home. So always look for that. It's in the code, it's in the statute. The court should be considering that. Cite it to them. It's always helpful too to have a letter indicating that there is space for both your client and their child. Oftentimes I had a case where I have father but mom said there was placement and there wasn't, so she went to the program and then she heard and found another one, but then our court didn't trust her because it was like, that was a condition that I put in and you lied. So we always try to have a letter. Always be mindful too of asking your clients, especially ones that are positive at birth. I think it's important to ask, how did they deliver? Was it cesarean versus vaginal? Because I've had a case too, actually, well, mother tested positive for amphetamine, but the doctor admitted that she had medicine via her C-section that caused the false positive for amphetamine. So that might be something that you want to inquire right away from your clients. How did they deliver? And this client had a long history. She had lost children through adoption too. I had father, but it was helpful to know that. And then it also put something in our court's mind. So every time we had a case, he would inquire of counsel, was mom's delivery by cesarean or vaginal? And then sometimes we were like, oh, it was vaginal, so that probably was a positive test. But, it is worthwhile to ask those questions to find out what exactly it is. And let's see. Not anything else. What also angers me is that we also have this blanket dispo case plan, which I believe, I don't know who created the form, but I think it's judicial officers, but this whole testing, if dirty, going to the program, hate it, because there's always obviously reasons why your clients miss tests. Some are legitimate, some are not. If you aren't doing it now, I would encourage you to always tell your clients to keep their yellow receipts and their white receipts saying that their name wasn't on the list, just everything. But I have seen, and I would encourage you guys to try it and see, but I have done, a certain amount of the tests if father misses or test is dirty for the department to file a 388, because that gives you an opportunity to have a hearing and to be heard on whatever evidence they had. And your client could possibly bring to you a work note from his employer saying that he was doing construction and I sent him to Palm Springs. Our clients always feel that they're never heard. They feel like they are limited to who they are on that paper. So whenever you give them the opportunity to express themselves and voice, what is really going on in their opinion, that goes a long way. And it also, some judges, they remember these things and they want to know, like, maybe, Devin, there's a reason why your client, didn't test this day. And they're open to hearing those things. Not all judges are. The ones who are more empathetic do. But, think of that. You can also ask for the department to walk it on. But your clients have to assist you too. They have to call you and let you know, hey, Devin, I missed this test. I actually had a visit that day. But they're not always going to do that. And sometimes your clients disappear, so you won't have the luxury of following up with them. And then sometimes they just don't test because they don't want to test. So just keep those things in mind as well. Let's see. I also think it goes a long way too for your clients. Judges remember clients. They remember them when they came in at detention and they were under the influence, or they were super skinny and their face was jacked. And then they remember later when they're like healthy, nice and tan, eyebrows are there, like they like it. So the court also likes when parents make the decision to have their children in their program but decline because they want to work on themselves. Now, that better be a child that's with a relative and not in foster care. But that shows the judge, when you come back and you're asking for that unmonitored or that overnight, he's like, yeah, because mom made that choice back at that hearing not to get her children to focus on her sobriety, and I appreciate that, and mother's testing clean, of course she can have her unmonitored, her overnights. So you really have to delve into who the person is, especially when you're at those real important hearings where you're trying to get return or better visitation to get your client their children back. And it just takes a little bit more time than we always have, but it's worth it in the end. When my clients are successful in their programs, they always give me a hug and say thank you, and I turn around and say you did all the work, because I don't know what it's like to be going to those classes, taking buses, learning my steps, and really taking a moral inventory of who I am as a person and why I've done the things that I've done to put me in this position. And I always tell them too, when they relapse, like, don't apologize to me, apologize to your children. Because I didn't, that is what you're working for. So that's essentially it. You have to know your client. If your client's going to get up there and act like they're high because they are high, like, don't do that. I mean, they have their own rights, and you can let them know under, against the advisement of counsel, Dad's going up there, and just keep it brief. Sometimes they just want to say, like, no, I didn't. And you're like, okay, cool, no further questions. Like, come on back. I've also had to have clients not appear at detention because they were clearly under the influence. I'm like, can I just waive your appearance because I can't with you right now. You're sleeping outside. You're just not right. So we're just going to submit today and figure it out later. So, I mean, you want to look for that. You want to look for your client who has, like, the marijuana tattoo on their hand or the shirt. Like, friend, I would like for you not to wear that next time, or try to wear long sleeves. I mean, a lot of it, our judges aren't supposed to judge our clients by how they appear, but they do. Let's be honest, they do. So that helps as well. I don't think I have anything else. I think we're going to open it up for questions. So any questions? Oh, Frank.
What was that case again?
NRA NK, let me see. It's 2015. Cal App. Let me see. It just says unpublished, 7604, whatever that means. It's a Lexus. But it's from Zeke's courtroom, Zeke Zeitler. And the appellate number is B262659. B26. October of 2015?
Thank you.
Yeah.
26259?
Yeah, 262659.
Thank you.
So, I mean, you can cite to those, but it's helpful to use it in terms of gauging your testimony, what the department did and allege, which you can use to bolster your case if they didn't have the facts. Just flip it on them and be like, oh, they didn't include that, but I'm going to give the court more than enough to determine that there's no risk or no nexus by eliciting these statements from my client. Okay?
Were there any other questions? I did want to add on to one thing that Devin had mentioned, because yes, those missed tests are such a killer, because everyone, I mean, it's on the case plan, any miss or dirty, and then boom, you have to do a program. And I did have the experience one time. I had a client who, I think he was ordered to do 8 tests. I mean, they were a lot of tests, and he was a truck driver. And he made it to a lot of the tests, but he had, I think, 1 or 2 missed. And so, of course, when we came back at the 2&E, the department was asking for him to do a full program, and I made I set it for contest. I made a lengthy argument about why he should not have to do a program. I cited the number of tests that were all negative. I talked about him being a truck driver. I talked about the fact that he specifically had a profession that required him to be sober. The judge did order him into a full program. I appealed it and won. So by the time it came back, we had direction, and it was interesting because the department actually ended up returning. It was at the 2 and F or the 2-2, the recommendation was home of parents, and including my client. So but I didn't know that that was going to happen. And we've all seen that situation where you get to the 2-1F or the 2-2, and they say, well, he never completed that aspect of his case plan. So that's why I appealed it. We went on the appeal, and we were sort of prepared for the worst case scenario. So it's just something to consider also, that you can appeal other orders of the court to protect your clients. Oh, fantastic.
I don't have a question.
Okay, good.
I always tell my clients, if they know they missed a test, to immediately call the social worker, leave a message and ask for a makeup test. And then I also think it's important to note with missed test date, if it's pre or post dispo. Because I have had clients miss tests before dispo, and then it's used against them 6 months later when I make the argument that the order goes from dispo. I've used it both ways. And then the PAC Talks test results will tell you if it's on demand or random. Because I've had clients who they've said they've missed tests, but it's on demand at a different testing location. So you should always look at those in detail. Don't throw your attachments away.
Yes. And also, Jazz had a case where the marijuana levels were going down. And the department kept sending, I had the mother on the case, and the department kept sending in these reports, well, the father tested positive, so he still hasn't done his program. But it was because the first test after the disposition was a lower number, and then the next test was negative. So it clearly showed that his marijuana levels were going down. And it was ridiculous.
It was a year later.
It was a year later. The kids were home with parent, father. It never even should have been an issue, but sometimes, I mean, it is a good idea when you have a marijuana case just to put it on the record. And I will just say that Jasmine was not the attorney at the trial or the disposition. But it is something to consider. Sometimes, I think we all sometimes forget, but we all, you know, everyone should try to remember that when it is a marijuana case, ask that the case plan state numbers to be going down. If the numbers go up or stay the same.
Although, Emily, if you have a case where the numbers go up, bump up a little bit, that's not necessarily indicative of use because it's stored in fat cells. And from what I understand from speaking to toxicologists, is the numbers can kind of bump up and down before there's completely negative results. So if you have, I mean, obviously, if they tested at 200 an hour or at 1,000, they're probably getting high. But if it's 200 to like 225, you may want to consult with a toxicologist and see what, because the judges seem to think that if any number goes up, it means that they're using, and that's not necessarily the case.
Thank you.
Yeah, on the testing, I think that was a good point. It says the testing location, it says whether it's weekly or on demand. I think in September, October, they switched the system. So when they call in every day, you push 1 for weekly or 2 for random or vice versa. So people are going to the wrong tests and not being tested appropriately. So that should be checked. And Judge Macbeth in 420 actually, for that little test so many times, says for the testing results to remain for medically acceptable levels. Now what those acceptable levels are, you know, we haven't defined it, but if it's anything under 200, she's good with it. And we've been able to have the department kind of eat it on that one.
That's interesting.
That's different.